The centre has obviously been admitted as the friend of the court. Just upfront, what is your interest or the centre's interest in this case at this point in time?
So, as a friend of the court, you're not actually one of the parties. So, what a friend of the court does is it helps to inform the court around various other issues that pertain to the substance of the case. So what we're really doing is we are going to give evidence from other jurisdictions around how the right to die has been enacted in those countries or in those states, as in Oregon in the US. And we are really saying to the court that if a right to die is found, which we assert there should be, look at the different jurisdictions and see how different jurisdictions have made laws and policies or tailored laws and policies that fit their culture and their legal system. So we're just advising the court around the different jurisdictions and what types of policies you can really enact.
Yes. So basically, just to understand it, in more simple terms, you are basically giving expert evidence.
Yeah, so we will have experts from let me just straighten that up a bit. We will have experts from various, there we go. We'll have experts from Oregon, the Netherlands, and Canada, and they will really speak about what's happening in their countries or their states and how the rollout happens in those places.
Yes. Now, obviously, we're going to be hearing a lot of legal arguments in this whole question surrounding the rights to dignity, the rights to life, and, at the same time, looking at it against, whether this is going to be inhumane, is it going to be cruel, and the like as well. And we know that, euthanasia can be a highly controversial topic. And depending, which angle or where you're looking at this. Now, this case in particular, if we can just understand some of the dynamics surrounding this case and why this case is so relevant and why it is being heard in the South Gauteng High Court.
Okay, so the relevance of this case is that if an individual at this point in time in our law wants to be assisted by a doctor, so a physician, a doctor to die when they are terminally ill, they have to apply to court to do so. What this case seeks to do is to make legislation around the entire process so that those who want to use this process, who are terminally ill, would not have to apply to a court and go through that entire process to do so. There would be policies in place for them to do so. Going to court is extremely expensive. It takes a long time. I mean, this case particular, we've been probably working on it for about 3 to 4 years. And we've only reached the hearing stages, or at least the beginning of the hearing stages at this point. We still foresee it going to the Supreme Court of Appeal, the CC. So not every person should have to wait that long with an application to have their terminal illness or their death hastened. So it's really, I think that's really the kind of foundations of this, as well as acknowledging certain rights and exploring whether these rights do exist within our constitution, such as a right to die.
Yes. Now, Sheena, obviously there are other parties that are opposing this entire case as well, where we're looking at organizations like the Health Professionals Council of South Africa, and we also see the Ministers of Health, Justice and Correctional Services, and also the National Prosecuting Authority, who are opposing this application.
Yeah, so we have what you can see in normal terms is we have the state opposing it. So those are the various arms of the state. So your legislation arm, your law arm, and your prosecuting arm, because if you do this at this point in time, it is a crime. But then we also have the Health Professions Council, which is the overarching body really looking at what their doctors and their professionals do. So these groups are opposing it for various reasons, based more around implementation of this, based around arguments that palliative care is sufficient. And those are really the main threads of the arguments that are opposing this at this point in time.
Yes. Now, obviously, this is not a straightforward, case that because there are many other issues that will arise out of this case, and some of them can become very, very technical because when one looks at the Health Professionals Council of South Africa, they are obviously looking at what they call physician-assisted suicide or euthanasia, saying that these are not medical services. Now, again, yeah, we're talking about a definition of what constitutes medical services, what doesn't. So this can become a very, very technical argument that is being put forward.
It is extremely technical. I mean, we started some of the hearings from one of the terminally ill individuals yesterday, and the degree of technicality, which for a lawyer is but ironic to say, is shocking because it's filled with medical terminology. It's also filled with questions of morality, and it's filled with questions of autonomy and how these types of things can convolute the entire situation and make it very difficult to find a very clear answer to all of this.
Yes. Now, in terms of the expert witnesses from overseas, and you mentioned Netherlands, Canada, and also the United States of America, who are we talking about? Who are these expert witnesses or those who are going to be presenting this expert evidence?
So with regards to our expert evidence, we have Suzanne van der Vathorst, which is an expert from the Netherlands. She's actually a physician and a professor that is on the euthanasia board in the Netherlands. So euthanasia is practiced in the Netherlands in varying degrees. We also have Dr. Blackmer from Canada. He is one of the doctors who also presides over one of these boards. Now, when I say sitting on these boards, these are boards who make, because actually, let me pause for a second, because this is really technical when it is enacted, you can't just say, I want to die, and a physician assists you in doing so. You have boards that have to see that you're not coerced, you're not acting under duress. So these individuals are really acting on those boards in those jurisdictions. And then we have Ann Jackson, who's from Oregon, and she is a former palliative care specialist who is now also arguing that along with our palliative care, there should be the option of a right to die. So she really sees it as being on a spectrum.
Yes. Have we got any? Have there been any? Cases historically where this case, obviously, in South Africa, where the case for euthanasia has actually come up in South Africa, or is this, a groundbreaking case at this point in time?
So, from my research, what we do have is we have about 3 historic cases where individuals have acted in what has often been in legal terms called mercy killings. So a husband may be assisting his wife to die. We have had a case where a physician assists a person to die. But the main case that dealt with the actual facts of this case was the Strantham Ford case, which I'm sure a lot of people remember a couple of years back. And that really dealt with the question of permitting or making a physician-assisted death legal. But as many will know, Mr. Strantham Ford died on the day that the courts handed down judgment. And in legal, and it's very technical, what we say is then the issue becomes moot. If you don't have a plaintiff, you can't have a decision. So this is really the first case since Strantham Ford that will explore the facts of physician-assisted dying, euthanasia. And because it's also cited in the interest of public, if the 2 individuals who have brought this case pass, the case will continue.
Yes, and just finally, Sheena, just as far as these 2 patients are concerned, what do we know about these patients? And also just to try and understand whether they are in the right frame of mind to obviously make this decision or to take this decision. And that is the reason why this matter has gone to court.
So, yes, at this point, what we have seen is that when these 2 particular individuals have been giving evidence, the evidence really does start with looking around whether they are in the right state of mind to first be giving evidence in this matter. what we have to know is, at this point in time, it does seem so. But even if these two individuals are in the right state of mind and physician-assisted dying comes into effect and is legalized, they would still have to go through the hurdles of being in the correct state of mind once that became legal again. And they may not actually be in that state when or if this becomes law.
Well, let's just see what materializes. I'm sure that, obviously this case is likely to still take much longer because there's still a lot of ground to cover in this particular case. And in terms of the courts, it's deliberating even after the expert witnesses. So it is obviously going to be quite interesting. These are developments that we will follow. But for now, Sheena, thank you very much for your time with us here on Salam Media.
Thank you for having me.
Sheena Swemmer joining us this morning on this case that is being heard in the High Court with regard to legalizing euthanasia for terminally ill patients.